I think it speaks well of the regard in which the judiciary is held, that those options, as far as I'm aware, were never even really considered by the Nixon White House. It goes all the way back to Marbury versus Madison in 1803, that it is the province and duty of the judiciary to say what the law is. Somebody has to have the last word. And in our society, it's the Supreme Court. Justice Robert Jackson, one of my favorite justices from the 40s and 50s, had a great line about the Supreme Court. He said, "We are not final because we are infallible. We are infallible because we are final." Somebody has to have the last word. It's the Supreme Court. And I don't think even Nixon, with all his contempt for other institutions of government, seriously considered defying the Supreme Court at that point.
Mr. Toobin, I'd like to digress for a moment. I turned and looked to the podium even though you're not here. I learned on the internet recently that in late October you're going to appear with another favorite son of Cleveland, Andy Borowitz, at the 92nd Street Y in New York. Would you please comment on your friendship with him and what that's all about?
Well, it's all roads lead to Shaker Heights. Yes, Andy and I are actually college classmates. So we've known each other a very long time, and for a while he had a gig on the American Morning, the morning show on CNN. So we'd see each other very early in the morning frequently. Andy is a remarkable polymath. He also had the very good fortune to be the co-creator of Fresh Prince of L.A., a show that, I don't know how to put this, means he doesn't have to work very hard at anything else for the rest of his life. We should all have such good fortune. But, Andy is the rare person who has a website that people actually look at. Everybody in the world has a website, but, most people have no viewers. But the Borowitz Report is, an actual going business enterprise. And he's really funny, and if I may plug both, we both have pieces in the current issue of the New Yorker. I have a piece about Leona Helmsley and her effort to pass her fortune on to her dogs, whether that's legally appropriate. And Andy has what's called the Shouts and Murmurs, a comedy piece. So he's a great guy.
You spoke about the ideological differences among the members of the United States Supreme Court, two blocks that they're in right today. Yet when a case is admitted to the Supreme Court of the United States, the attorneys file briefs, they have oral arguments before the court. To what extent do you think that these actions are almost, I won't say worthless, but fairly close to it, in view of the fact that these justices have made up their mind on what side they're on?
Well, I think it varies a great deal by case, and I don't want to overstate the political nature of the court. Throughout the recent Supreme Court history, about 40% of the justices' cases are unanimously decided. And, in the 80 cases, I would say 50 to 60 deal in issues that are, if not entirely apolitical, not intensely political. And in those cases, I think the justices, approach each case, with an open mind and with, read the briefs and just try to figure out the right thing to do, and they usually collaborate in the result. But when you get to constitutional issues that are so wrapped up in politics, the justices don't need to read briefs to decide whether they think Roe versus Wade should be overturned. They don't really need to read briefs to know whether a university can consider race in admissions. Those decisions are highly, highly political. Now, and I don't say that in criticism of the court. I think it's inevitable. I think there are no ways of approaching that issue in an apolitical way. But that's how the court. So I don't mean to leave the impression that they're just like a bunch of senators up there who make up their minds based on the political winds. They do read the briefs. They are serious about their craft, and craft has a great deal to do with how they decide most cases. But when you get to the really high-profile cases, I think that politics plays a great role.
Do you think that there should be some form of mandatory recusal on the court? I think, of course, of the O'Connor vote and Gore against or Bush against Gore.
I trust the justices pretty well. I don't think they have to recuse themselves much more than they do. I actually, in the 9, come to Justice Scalia's defense about the famous duck hunting incident. When he went duck hunting with Vice President Cheney, and then ruled in the case where Cheney was sued for the documents in the Energy Task Force. I just think that the government gets sued all the time, and the president is a defendant in hundreds of cases a year, as is the vice president, as is the attorney general, and the reason you get appointed to the Supreme Court is you have some familiarity, friendship with the people in charge. Now, Harry Truman used to play poker with Supreme Court justices. So did Franklin Roosevelt. Abe Fortas, I think to an unhealthy degree, was still involved in the Johnson administration. So I really don't think that that there are a lot of recusals out there, certainly in the contemporary court, that should be made but weren't.
Mr. Toobin, I actually heard Justice Scalia say, why have all that power if you don't use it, in the context of Bush versus Gore? And my concern is that election law is a fragile area of law, and equal protection is an area of law that could swallow up almost anything. Now, you've already suggested that on certain issues the court is politically biased. Were this election to go to the Supreme Court, could there be any principled outcome?
Boy, it would probably mean another book for me, which is a good thing, if this went to the Supreme Court. You know what? I would take issue with the word biased. I don't think that pejorative term is appropriate. You compare Justice Ginsburg and Justice Scalia. They are both intelligent. They are both skilled. They are both ethical. What separates them is judicial philosophy. They simply view the Constitution differently, and that's inevitable. And there's nothing shameful or inappropriate about that. The Constitution cannot be interpreted, in my opinion, in a neutral way. You have to have a philosophy, and that's never going to be different. Frankly, if I thought this case, I mean, the problem with Bush v. Gore, I mean, my book is not a polemic that's thumbs up, thumbs down on every justice and on every issue. But the problem with Bush v. Gore is which is a decision that unapologetically I say was, I think, a very bad decision, is that the most we can hope for from justices is not that they be apolitical, but that they are principled politically. And what it means to be a judicial conservative is that you believe that states should be allowed to run state functions like elections. And what it means to be a judicial conservative is to have a narrow conception of the Equal Protection Clause when it comes to, say, black people and women. So when a plaintiff named George W. Bush claims that a state function like an election should be overturned on the ground of an equal protection law against him, equal protection violation against him, you as a conservative should look skeptically. And when the 5 conservatives embraced that view, I think that betrayed a political orientation that was not the usual kind of judicial philosophy, but more just naked politics. And that's why I think it was such a low moment in the court. But hey, I welcome this election into the court as well.